Yeah, it's unfortunate. So yeah, thank you. So let's jump to the next section of our conversation. So Vera, we talked about how we were just going to go over, kind of, because a lot of people are not familiar, right, with the criminal justice system and how that process works, right? The moment that they are charged, I'd love to see if we can just kind of go through kind of the different, the steps, right? So that in case there is somebody listening and maybe they have a loved one that's been arrested and then they kind of we'll have an idea just roughly, right? Because it varies, there's always motions that get filed, but I'd love to see if we can just kind of go over generally what that process looks like
Yes.
For somebody that's not familiar with the criminal justice system.
Yes. So the start of any criminal, investigation, right, is when the police is actually, investigating in a case. That starts either way, they become aware of it, right, by a suspected criminal activity, or they get a report from someone, right, from a victim or from someone that is, that has, any disadvantages. So either way, it's a report, or the police officer himself or herself, they observe something, right, that is suspicious. And after suspecting a crime, it's only the suspicion in the first place, right? There's no evidence in this section of the case. The police might need to gather more information to see, do they get interviews from witnesses, right? Is there any physical evidence? Is there legal evidence, right? Can they take any photographs, videos of the scene, right? Is there anything available to them? And then if there's enough, right, they might apply to the judge who is, in this jurisdiction, who is available and who is the right judge to turn to this case. They might seek a search warrant, right, from the judge. And if the judge authorizes that, they can get into the location itself, right, and even into homes, access homes, access phones, access cars, right, and look more for evidence. So yes, and also at this point, the officers only with a search warrant, right, they can also investigate vehicles, as I said, cars, phones, records, any type of DNA like blood, urine, right, skin, even skin particles. And if there's enough evidence in the first place, if the suspicion is there, they can go forward and make an arrest, right? This is like the first step actually for a suspect, or for the person who is a suspect in the first place, an arrest. If there's
Sorry to interrupt you. Can I interject for just a moment? Something interesting that I think our listeners and viewers would appreciate. So there's this doctrine, right, called fruit of poisonous tree doctrine. And fruit of the poisonous tree doctrine, maybe you could talk about it a little bit, but it has to do with, when they gather evidence without having a search warrant, right? When they don't have the legal authority to do that. If you don't mind, just maybe briefly cover that. I think I see that come up quite a bit, you know what I mean?
Yes. So that doctrine what essentially means is that something that is discovered, in the discovery phase, in the first steps, long before a trial even starts, right? Something is received illegally, right, without even the legal search warrant, or by not accepting what the orders in place, or a police officer went somewhere, and he did, for example, he did collect different DNA and did not change the gloves, right? Or there were certain fluids and they just collected everything and put it into one box, right? Or something was taken from the crime scene and was not delivered immediately to the police department, right? It was just like driving around with a car, going to another crime scene, right? For example, so those things would lead to, that piece of evidence cannot be used anymore in the trial, right? Because it's not, you cannot rule out that there's something, that could be contaminated, right? Or could, it's like, it's an illegal source, pretty much. So that means pro suspect in this case, right? If something was not done right by the law enforcement officers, can be picked up by the defense attorney and will be picked up, right? So it cannot be used anymore in a trial. And there's also no way back, because once once the court system is involved, right? They cannot go back to the day and time when the crime was committed, right? And when the crime scene was investigated, because that's probably like maybe a year or even longer ago. So that cannot be recovered anymore. So that's if that is, if that is done, if that is done and a legal source of evidence was in the picture, that cannot be used anymore, and it cannot be in any other circumstances be accepted in the trial.
Yeah, awesome, cool. So sorry, right before I interrupted you, I think you were going from investigation, and thank you for that. And then you go to arrest. I think you were at arrest, right? Okay.
Yes.
Okay.
Yes. An arrest can only take place, and that's very important because most people think they cannot get arrested, right, until there's any proof. That's not true. So an arrest is when there's a probable cause. That's less than proof of evidence, right? We're still not in court, so we don't have to have, a certain kind of legal evidence yet. We have to have a probable cause. That means that it is likely, it could be the case, it doesn't have to be at this point, that a certain person committed a crime, right? So that means either because of a report, right? The suspicion is enough for the police to investigate and to make an arrest based on the evidence that was collected in the crime scene, at the crime scene, or because there's a warrant from the judge, right? Based on the first information that they could retrieve from the crime scene. So it's still not any kind of evidence yet, right? It's only a probable cause, like it's likely that a person committed a crime. So that's what we also speak about main suspect, and sometimes we have either several suspects, right? That are not even connected to each other, right? So that's why people speak, like law enforcement speaks of a main suspect in a lot of cases, because it's not the sole suspect.
Sure. Okay. And then after that, then somebody they're arrested, they're booked, they're charged, and then there's an arraignment, right? And I think booking and charging is
Yes.
it's pretty self-explanatory, but the arraignment, can you explain what's the purpose of the arraignment?
Yeah, so before the arraignment, there's, as you said, the charging a crime. That means, like, also for people to know that it's called a complaint, right? So the prosecutor has to file this complaint to the court, right? And the criminal charges begin at that time, right? So also it has to be determined if this will be, a grand jury or a petit jury, right? So that's also a step to determine how many jurors are deciding over a case. And then after reviewing those reports, of the investigators, the prosecutor can charge the suspect, right, with this complaint. So that's, like a very important step before we come to the arraignment. The arraignment is it always is the so-called, in natural terms, it's the first appearance of a suspect in court, right? The very first appearance. Arraignment is not, it is, yeah, you can say in a lot of states an arraignment is always mandatory, not in every state. But it's typically the first appearance that someone comes before a judge at all, right? And it's very important that the suspect is getting the arraignment very shortly after an arrest, so they cannot just put someone in arrest and leave him in jail or leave her in jail. They have to at least, within 2 days, which is a very short notice, right? Get the arraignment date, so the suspect can appear in front of the judge, right? And in this arraignment appointment, the judge will normally advise the defendant. They will, for the first time, read the charges, right? Tell him what the charges are, why this person is arrested and in jail at this point, and also the maximum and the minimum penalties at this point, right? Then they will have to read all the constitutional rights, that the criminal defendant has a right to an attorney, right? If he cannot afford one, he will get appointed a public defender, and also that he has the right for a speedy trial, right? And also a jury trial, because in most I will not say every every criminal case, sorry, but in most criminal cases, there's a right to a jury trial. So very different from civil law where there's no jury trial. And a lot of defendants, when I make, the research in this topic, a lot of defendants actually choose a jury trial over a bench trial, right? So that means they have to plead not guilty, right? Because if someone pleads guilty or non-contested, that means that they're not going into the jury trial itself, right? But if someone pleads not guilty, the trial has to start, right? The complete trial has to start, and they have the right to a jury trial, which is very important, right? It can be advantage, like as we've seen, a lot of benefits, but it can also have like disadvantages if you got a jury that is easily manipulated, or who is like emotionally driven, right? Or you have like, it's hard to say, right? It's hard to say how a jury is going to be, because you can reject jury members only if you have a very certain cause, only if you can show, right, that a jury member might not be unbiased in a specific case. But it's hard to actually reject someone, right? If you just think someone might have, a problem with the defendant itself. So yes.
Yeah, and then just for our audience, I'd love to be able to clarify kind of what that process looks like, and please correct me, but there's, where they strike potential jurors, right? So you have 100 jurors, and you can strike jurors initially, what they call for cause, right? Which is what you were talking about, where there's maybe if somebody has a history, if they have a felony, or if they have a history with, they know people that have been charged with something similar, or victims of
Yes.
something similar, or any number of things, right? But that's for cause.
Uh-huh.
And after that, then you have what they call peremptory challenges, right? Where, because for cause, like the prosecution and the defense, they have to actually explain why they're trying to eliminate that juror, right? They could say, oh, this juror, was sexually abused, so we think they're going to be biased, right? And the judge gets to decide. If the judge is fair, he'll go ahead and make a good decision. If not, But then on the peremptory challenges, like they don't have to explain, right? The prosecution or the defense, they don't have to explain why they're eliminating jurors. And it's like almost like round two, right? So they start off with 100, then they narrow down to like, we'll say 20, and then 20, then they eliminate them down to like, we'll say 11 or 10 or whatever it is.
Yes.
And then, but those final eliminations, that's where you have the peremptory challenges, where they don't even have to explain why they want to eliminate those jurors.
Yes.
And each side gets to eliminate one at a time, right?
Yes, exactly. In a petit jury, you have between like you either have 6 or 12, right? And in a grand jury, you have not, it cannot be fewer than 18, I believe, until like 21 usually, right? So it always depends on, of the type of case, if you get a grand jury or a petit jury.
Yeah, yeah. Cool. And then we have pre-trial motions, right, that take place. Maybe if you could talk about maybe just 3 examples in general of pre-trial motions that take place prior to actually going to trial.
Yes, so that always depends from state to state, right? There cannot be like, there's not a general explanation to that. Like you can submit motion right before you actually the trial can begin. I also wanted to say something about the right to an attorney, because a lot of people forget that, right? It's like commonly used. Yeah, of course you have a right to an attorney, but a lot of people, as you said, cannot afford their private attorney because they're costly, right? They charge hourly fees of like $100, $800 or $1,000 sometimes, right, per hour. So people who don't have the means, they cannot afford like one of the best attorneys, right? That's also a big problem, because how can you guarantee, a fair trial when someone is appointed a public defender? There are good public defenders, of course, right? But it's not, you will end up with someone you never spoke to, or you didn't choose, right? It gets appointed by the court. And then you have to trust this person, that this person is motivated enough to actually represent you and defend you the best way possible, right? And puts a lot of effort and passion into your case, which I highly doubt, right? Because it doesn't get paid well. So if someone is not, compensated well enough, how do you guarantee that the suspect gets the right and the best defense, right? That's also something that it's in the law, right? There is the right to an attorney. Yes, that's true. But on the other side, when it comes to the real cases, reality, then it's like, okay, whoever has the means can hire 1, 2, 3 defense attorneys even, right? And they build a team and they have a lot more resources, right? So the more people who work on your case, the more you get also out of it, right? Of knowledge. And if you don't have that, then it's like also you can still hope for the best result, but you already limit your options at this
Yeah.
point. So it's always about, can you afford it financially or not, right? Can you spend, a lot of money on attorneys or not? It's very unfortunate because it should not, fairness itself should not depend on if someone has the means or not, right? Because you don't know the background. Maybe, the person lost a job, right? Or the person has a lot of kids, or the person just, has bought a house, right? And has cannot just afford those additional costs for an attorney, right? So there are different, it's not always about, did someone just not save up for a case like that, right? For something like that to happen. It's a lot of different, background stories in what I experienced with clients, that they, just invested in a house, right, for their own family. So they don't have the means to go ahead and just spend like a lot of money on attorneys. So they end up with a public defender, and you can hope for the best and get an amazing public defender, but it's not guaranteed. So that's something also to consider, right? Because it's in the law, right? It looks very good on paper, but it's difficult when it comes to real life and the suspect in a case.
And to connect that with something we said earlier, I mean, we were talking about making bail earlier, right? And the connection between making bail and are you truly innocent if you're sitting in prison or in jail, right? With all these consequences. But to connect that back to that, we were talking about how difficult it would be for somebody to be able to afford, say, $5,000, right? Or $50,000 to make bail. But when we're talking about legal representation, generally speaking, depending on the type of charges, right? But generally speaking, you're talking about much bigger amounts of money.
Yes.
If somebody's being charged with something pretty serious, now you're talking about attorney fees, like what you just mentioned a minute ago, $80,000, $100,000, $60,000 for a private attorney. Who can afford that, right?
Yes.
Like what percentage of people in our society are able to pay for that? And especially now, if they're in jail, can't make bail, so more likely than not, people end up with public defenders, right? The average person. Yes. And what you just mentioned about, public defenders, it's interesting because, and I don't think most people realize this, but this is, at least here in Utah, it's quite common for a defendant to have never talked to his trial attorney, right? His public defender, or have talked to him just minimally, for evidence to not have been investigated, and then they go to trial, right? Just barely talking to them, just maybe a handful of times. Yes. And there's all this evidence that hasn't been investigated, and then they go to trial. How is that a fair trial? How is that an attorney, right, under the Sixth Amendment? You know what I mean? Yes. So it's this like you said, it's something that looks good in on paper. Yes. But the reality is that it's not like that. And I think it's unfortunate. And this is for everybody. It doesn't matter what race you are. All that matters is, can you afford $100,000 for a private attorney or not? And if you can't, most people can't, then you're being subjected to a system that is not really, right? If we can be totally honest, it's not fair. Because now you have an attorney that knows nothing about your case, has not talked to you, or knows very little about your case. And now he's taken in front of a jury, and the prosecutor, like, they're usually very well prepared. Like, from what I've seen, like, even on the smallest case, they got the resources and the time and the energy to be able to invest into it. So it's like, good luck.
Yes. So that's a big problem, right? There's no relationship between the attorney and the suspect. So it's not that you know each other, right? And you pick someone because of experience, because of his knowledge, or because you trust this person, right? If you pick a private attorney, you usually have a relationship to that person, right? The person represented you in another case, maybe, right? Before, or you got this recommendation from a family member. So it's also like if there's no bond, so it's hard for both sides, right, to go into that trial and to, the suspect has to trust the attorney fully, right? Because if the attorney says, please don't say anything, right? I have a strategy for you, and you should, follow my lead. And the suspect is very, frustrated because he wants to speak up, right? That can cause also irritation. That could cause also friction, and lead to exchange of a public defense attorney, right? Or also the petition for a suspect to the court. I want to exchange that person because I don't believe that this person does the best for me, right? In my interest. So that's also a problem when when you're trying to trying to exchange the public defender, because it happens quite some time, right? Because both people don't know each other, right? The attorney wants to just get his job done, right, as best as he can, but also the suspect is in a highly emotional state, right? He's highly anxious. He or she is highly anxious, right? That happened probably never began in the life before. So they're very frightened of what might happen, right? And you're already not very trusting of anyone around you, right? Because now you feel like everyone is against you and you have to prove to the entire world what happened, right? And you want to speak up. Most people want to speak up, but they are shut down by the attorneys because they say, I have a strategy and I have the experience. Please trust me, right? That this is better for you. And, in a lot of cases there, I see, that they're not getting along. They're not getting along well. And that is also something that the jury members, the jurors, will see, right? They will feel if there's, friction, or there's, they are not going in this courtroom together, right? They are not really, the attorney is not backing up the suspect, and the suspect doesn't trust the attorney, right? So that's a big problem too, because they had almost, as you said, no time to really get to know each other. Probably 1 or 2 times visiting him, right? In jail, but usually not more than 2 or 3 times, right? To speak a little bit and not really taking a lot of time because it's not paid, right? This time is not paid for him. So that's a problem, and the juries will sense that, right?
Yeah, I agree with you. If I could take us back on track, and sorry, we went off on a tangent here, but we're talking about pretrial motions. I know that one of the motions, right, here in Utah, and I think it's the same everywhere, they call it a motion in limine, right? This is one of those motions where they submit before trial to, either side is putting in, to try to see if they can keep evidence out, or if they can, from the other side, right? And then we also have like motions to allow people to speak as experts, right? A lot of times you have to get permission, right, from the court to allow somebody to speak to, right, a subject that requires expert experience and credentials.
Yes.
Is there any other kind of motion that comes to mind that you can think of that's common, like before trial?
Yes, like emotions, as you said, that from either side to dismiss certain parts, certain evidence, right? That was, the defense attorney has like a lot of opportunities in this at this point to try to dismiss certain evidence, right? With a pretrial motion before the trial starts. So, but the judge has to decide in the end, right? If those things are being dismissed or not. He can still say, it's rejected. I will, look at it, and I will still, take a look at it in trial and present it also, and have it presented to the jurors, right? So it's not a guarantee that something will be dismissed, but it's a good opportunity to try. And yeah, that definitely comes before the plea hearings, right? So the plea hearing is usually the next step in the court trial, when when we talk about the plea bargaining, right? This is generally when the prosecutor will provide a plea offer, right, to the defendant, or to his attorney or her attorney, and some negotiations can take place in this phase. Usually it's instead of going to trial, right? A defendant can accept a plea. It doesn't happen a lot, but he could accept a plea guilty or no contest. But that means he's cutting off any opportunities, any options to go into trial and to have a jury trial, right? But in exchange for that, the prosecutor could dismiss certain parts of the offense, right? Or certain charges even. And he also could recommend a milder sentence to the judge, right? That can happen, but on the other side, it's like you're cutting off your legal rights to a fair trial and to also for a jury trial. So most defendants, like at least from my experience, they definitely want to have a trial and a jury trial as well, because they think it's more, the more people who look at it without the legal background, right, the fairer it could become, right? It's not always true. We see a lot of cases where it's the opposite, right? But at least you have the option, right? To say, okay, I want to speak up. I want to have a jury trial. I want to have, unbiased members of the community, right? That don't know me and should have no interest in, before the trial, right? And we're presenting everything possible to them to make it, to convince them that, right, what happened. So it could go anyways, right? You never have the guarantee before a trial how it could end up, but the defense attorney has to advise the defendant if they should plead guilty. Some very rare cases that you should actually plead guilty if, for example, the evidence is overwhelming, right? The evidence could be overwhelming, and to make it the defense attorney tells you that you have no chance in being acquitted, right? Or you have no chance in being acquitted because there is no possibility, like from the experience, right? Then just to make the sentence, shorter, or to get a better negotiation with the prosecutor, to hopefully have the judge accept it. But it's only a very, like, I would say maybe 2 or 3% that the defense attorney would actually advise the defendant to plead guilty, right? Because his task is to defend him the best way possible, and not to have a short court trial, right?
And for clarification, you're talking about 2 to 3% that they should advise them to plead guilty. That's on the front end, right? Because on the back end,
Yes.
on the back end, I know that on a federal level, it's well over 90% of cases get settled through plea negotiations.
Yes.
And I say well over 90, I think it's something like 98% or something of cases get, settled through just through plea bargaining. They don't actually go to trial. At the state level here in Utah, I know that over 95% of cases actually get decided through a plea deal. But you're referring to like on the front end, right? Early on, right?
Yes.
They should plead guilty and then they usually don't.
Yes.
Okay. And then there's also, I think discovery is an interesting thing, and we probably don't have too much time to go really deep into it. We can always talk about it more in detail, but I think maybe something maybe you could speak to just on discovery. It's one of those things where the defense attorney has to constantly make requests from the prosecution, right? To ask them for all the evidence that they have, because it doesn't automatically happen in writing on paper. It does happen, right? They're supposed to disclose everything that they have. In practicality, that's not the case, right? Defense attorneys have to make 3, 4, 5, 6, 7 requests, or even more requests, discovery requests, asking, hey, send me everything you got. Hey, send me, on this stuff, on that stuff.
Yes, exactly. Everything has to be exchanged before, right? So both parties, both sides have to have, all the documents, the documentation, all the paperwork, all the evidence that will be presented in court to the juries, right? There cannot be any, surprising evidence that comes up, because that could be also, you could contest that, right? In trial, what happens if the prosecutor or also the defense attorney comes up with something that the other side has not seen? They will immediately step up and say, this has not been presented to court. We are objecting, right? And the judge will, in a lot of cases, not in all, but in a lot of cases, say, okay, that's, like it's rejected, right? It cannot be part of this trial because it was not presented to both sides in the first place before the trial starts. So that's very important too, that you have all the documentation, right? And the defense attorney has to be prepared as best as possible to be able to then, cross-examine the witnesses, right? And also, do first of all, of course, the opening statements, right? When the trial begins. So that's very important to not miss any option to be prepared.
Yeah. And by the way, we'll probably have to do an entire, conversation on just strategically, like, I think that would be fascinating for people, right? If, as a defense attorney, and with my experience and understanding, it'd be cool if we could come up with a scenario, right?
Yes.
We're representing a defendant, and then we're gonna take them to trial and then walk the defendant through the entire process, and then talk about strategically how we would defend that, that person. And I think that would be, such a huge benefit to our listeners and viewers. But in the interest of time, I'd love to see if you could just kind of maybe we could just wrap up like kind of what the next steps are in, right? So we've gone through discovery, we've gone through plea bargaining, pre-trial motions, arraignment, all that stuff that we've talked about. What would be the next step or the next few steps?
Yes, so the next few steps would be the as I said before, this is like the process when the trial starts, right? The actual trial. So as you said, like more than 90%, I believe, like in the common average in the US gets resolved through the plea bargaining, but like not pleading guilty in in the very first discussions, but still not entering the court, the trial, right, itself with the jury. So I believe that the opening statements would be the next step, that actually the prosecutor, once the jury is selected, right, the prosecutor and the defense, they have to give opening statements. First, the state attorney's office, right, and then the defense attorney, and they have to present all the evidence that to the jury, right, that they will just introduce the evidence that they will present and go into detail later, right? And after those opening statements, everyone, like every side presents the evidence, actually presents, everything in depth, as detailed as they can, right? And also have witnesses, like calling the witnesses, right? And then the defense attorney can actually cross-examine the witnesses, present any physical evidence, right? Contest against whatever is presented before from the state attorney's office, right? Take into consideration if there are any photos, any videographs of the crime itself. Go into detail and try to fight every single detail of evidence, right, that is presented before. Yes, so that's also for, it's like it's a presentation towards the jury, right? Because they're speaking to the jury. They're speaking to the ones that have to make a decision of speaking guilty or acquitting a person, right? So that's very important to show them, in a logical way, what happened and why what the prosecutor is presenting them did not happen, right? Or it happened in a different scenario, right? Or they did not take into consideration what actually happened. You have to present an alternative case, right? An alternative scenario that happened, and why, there were certain things missing, right? For example, they only focused on the suspect and did not take into consideration other people that might have also had a motive, or were, like close to that scene, right? Or they did not investigate everything that was possible at this point. So it's very important that the defense attorney speaks to the jury and presents everything in favor of the suspect.